and the waste hauler has not been paid, what will be the equity in your home then? To reiterate, if Betsy Seworth is allowed to continue as Silt Town Administrator, the town will be insolvent within 36 months. And oh, by the way, don't think that Washington or Denver or Garfield County is going to bail out this town. With all that said, I was stunned and outraged as I observed on local TV the insubordinate arrogance of Silt Town Attorney Eugene Duran at the February 8, 2010 trustee meeting. Citizens of Silt, as you should know, Mayor Dave Moore and Trustee Doug Williams expressed valid concerns over the legality of the 2008 Charter Amendment ballot measure, which spawned 2008 Ordinance Number 13 and subsequently Ordinance Number 1 of 2010. The Silt Town Attorney responded to Mayor Moore and Trustee Williams in a manner that clearly disgraced the American governmental process and verified that Attorney Duran is incompetent and professionally unworthy to continue as Silt Town Attorney. I have read the ambiguous language of the vague 2008 Charter Amendment ballot measure number 2. A high school civics student could easily determine the 2008 Charter Amendment ballot measure would never stand constitutional muster or the scrutiny of an examination by a learned judge in a district court in Colorado. When juxtaposed with the language and subsequent effects of the 2008 Ordinance Number 13, it is easy to see Number 13 illegally grants powers to the town administrator that are repugnant to the town's home rule charter. Moreover, by extension, the 2008 Home Rule Charter Amendment is also repugnant to the Constitution of the United States. Therefore, in order to protect the constitutional rights of we the people of Silt, Colorado, and to end tonight the Silt Charter crisis, the following measures must be taken by the mayor and trustees. 1. The Home Rule Charter Amendment ballot measure must be immediately declared by resolution as vague, obscure, and ambiguous, and having no effect on the town charter, and therefore is invalid. 2. Ordinance Number 13, 2008, and all 2008 related ordinances must be rescinded forthwith by the mayor and the board of trustees by resolution. 3. Ordinance Number 1, 2010 must be rescinded forthwith by mayor and board of trustees by resolution. Additionally, if Silt Town Attorney Eugene Duran actually wrote the language of Ordinance Number 13, then he is guilty of professional misconduct and professional malpractice. Accordingly, I herein make formal requests to have his acts, omissions, and professional legal opinions investigated by the Colorado Attorney General and the Colorado Bar Association, especially the section in Ordinance Number 13 where he declares an emergency, and Duran writes, this ordinance must be adopted immediately to preserve the public peace, health, and safety. If President Bill Clinton is not immune from losing his license to practice law, then neither is Attorney Eugene Duran. Beyond this, the 2008 Ordinance Number 13 places the chief of police under the direct control of the town administrator. Thus, Ordinance 13 removes oversight and control of the police from the town's elected representatives and gives oversight and control to the police by an unelected bureaucrat. Can you envision? Citizens of Silt, envision President Obama as commander-in-chief of the military abdicating his constitutional authority over the military and giving the responsibilities of military oversight to White House Chief of Staff Rahm Emanuel. Additionally, the shadow government, the trustees and town attorney have unconstitutionally created, illegally grants to the town administrator the power to appoint the new municipal court judge. Citizens of Silt, envision President Obama abdicating his constitutional duties and allowing Chief of Staff Rahm Emanuel to appoint the next Supreme Court justice. Furthermore, pursuant to Ordinance Number 13, the town treasurer is now under the control of the town administrator. The checkbook of the town, citizens, is no longer under the direct scrutiny of the town's elected representatives, and the control over the town's cash is now in the hands of an unelected bureaucrat. Not only that, citizens, it is my understanding all expenditures under $5,000 do not need trustee approval. Would you allow that to happen with your own personal checking account? Citizens of Silt, please listen to me very carefully. Telephone the town hall and insist that the town administrator continuously replay the town trustee meeting of February 8, 2010 on the public television channel. Insist upon this. Do not allow the town administrator to bury this video. During this trustee meeting, Connie Stevens, the town treasurer, presented the 2009 town budget summary. Watch closely your town treasurer and how she is keeping your books. You businessmen out there, you businesswomen out there in the town of Silt, can you imagine you running your business and your bookkeeping the way the town of Silt is running its bookkeeping? Watch the video. It's right there. Now, it is my understanding the town once had a very proficient CPA auditor on retainer. Betsy Seward takes power and becomes the town administrator, and the proficient CPA auditor was terminated, and now the town's 2009 books are unaudited. The abdicating town trustees approved the 2009 end-of-year budget summary without an audit. This town has $800,000 in cash in the bank, and the books are a travesty. I herein ask until April and the next Board of Trustees is elected and sworn in that Mayor Moore take the town's checkbook for safekeeping and sign all town checks. Furthermore, it is my understanding that 2 formal complaints have been filed against the town administrator. I don't know if this is true or not, but have the town attorney and the town administrator utilize the unconstitutional powers of the shadow government to bury these 2 formal complaints filed against the town administrator. Please investigate these allegations that 2 formal complaints have been filed against the town administrator, and the town attorney has covered up, lost the paperwork in the town's bureaucracy. Now, in 1803, the most famous case in the history of the United States Supreme Court was decided. This is Marbury v. Madison. When you file the formal complaint against Attorney Duran with the Colorado Attorney General and the Colorado State Bar Association, remind their lawyers of Marbury v. Madison. Marbury v. Madison is not unlike the legal controversy that exists today in the town of Silt, Colorado. Marbury was one of the midnight judges who was appointed by President John Adams the night before Thomas Jefferson was sworn in as president. Marbury was not confirmed as judge by Jefferson, and he then sued James Madison, the Secretary of State, in the U.S. Supreme Court, seeking what is known as a writ of mandamus, which would force Madison to issue to Marbury his commission to become Justice of the Peace. Marbury sued under the Judiciary Act of 1789, which was later ruled an act quite similar to the controversy surrounding the town of Silt, Ordinance 2008 number 13, and the vague and invalid 2008 Town Charter Amendment ballot measure. Supreme Court Chief Justice John Marshall wrote a legal